In Commonwealth versus Twill, the Pennsylvania Superior Court looks at a claim that Pennsylvania's new or newer statute on guilty but mentally ill is constitutional. Is it an acceptable way to treat people whom the jury has determined to be mentally ill? And the defendant in this case raises the argument or actually raises a couple of different arguments. He claims that first of all, that the jury will not be able to distinguish between guilty but mentally ill and insane. And the court says, well, no, that's actually not the case at all. Because if you look at the definition of these crimes, or look at the definition of these verdicts, guilty but mentally ill means that you have some sort of mental illness, but that at the time of the crime, you didn't meet the McNaughton definition of insanity. And we talked about that in the Kaler versus Kansas case. The McNaughton rule says that you are insane and therefore not criminally liable if you are unable to appreciate the difference between right and wrong. If that is what you were, if you were unable to appreciate the difference between right and wrong at the time you committed the crime, then you are not insane and you're not going to be convicted of the crime. Guilty but mentally ill means you may have then or at some other point had something that constitutes a mental illness, but that at the time you committed the crime, you appreciated the difference between right and wrong. It didn't mean you didn't have some sort of diminished capacity at the time. It didn't mean you weren't very seriously mentally ill. But if at the time of the crime, you knew what you were doing was wrong and did it anyway, then you are still guilty, but you may well be guilty but mentally ill. So the court says those two things can be meaningfully distinguished. Trill then says, but there's more to it than that. He said the problem with this verdict is that juries aren't real familiar with this kind of thing, and that juries may well either not understand it. The court kind of dispensed with that argument and saying, no, they're clearly distinguishable. But Trill's other argument is that juries might well just compromise and call him guilty but mentally ill. This is a much bigger problem in criminal law. We've seen this in a lot of places. That when you got a range of possible punishments for first-degree murder, and you've got a bunch of statutory language that juries really can't understand, won't they kind of compromise somewhere in the middle? Or if you've got jurors wanting first degree and others wanting involuntary manslaughter, aren't we worried about a concoction of jurors, none of whom actually think it's third-degree murder, but all kind of coalescing toward the middle? So the problem of compromise verdicts are absolutely everywhere in the law. And while the court in this case doesn't address that possibility, it says, look, you've shown us nothing unique about this. The court says, well, if you are worried about compromise verdicts, you can always poll the jury. Now, the problem with that is that it's actually not terribly helpful. What happens when you poll the jury is you'll go down with each juror, and the juror will say, that was my verdict and it is my verdict. That tells you nothing about compromise. And in fact, jurors aren't really allowed to talk about at any point that's admissible whether their verdict was the product of a compromise. The court talks about kind of how the Pennsylvania Supreme Court or the Pennsylvania legislature got us to this point in this case. This was a result of the attempted assassination of Ronald Reagan by John Hinckley Jr. and the fact that he was found to be insane. And therefore, once he was found insane, not guilty by reason of insanity, it was not the criminal justice system, but the civil commitment process that determined whether and how long he would be detained as someone who was, because of his mental illness, a potential danger to himself or others. And the Hinckley acquittal on the basis of insanity kind of struck a real fear in the heart of, of a lot of legislatures, including Pennsylvania. And as you can see in the case, a whole bunch of states began to change their laws to provide for this guilty but mentally ill category. So under this verdict, if that's what you're found, guilty but mentally ill, you will serve the length of the sentence for the crime, but you will serve it in the mental wing of the prison facility. So the reality then is that we may well have exactly the same result, because if you're found insane, then you're detained pending a commitment proceeding, and you will remain detained as long as you are regarded as a danger to yourself or to others. So this civil commitment process puts you in a compulsory mental institution, which often just happens to be connected to the prison. So the reality is that people who are serving sentences for being guilty but mentally ill are very often serving in the same place as those who are insane but not guilty. The only difference really being that the length of the confinement is, in the case of guilty but mentally ill, the minimum that you have to serve is the length of the prison sentence, but then you could still be held civilly if you're still a danger. Whereas if you're held as someone who is insane but dangerous, then you could be released much earlier than the prison sentence for the crime that you committed. So John Hinckley Jr. has, I'm not sure if he's been released at this point, but he's definitely been allowed to be furloughed. He may in fact have been released from incarceration or from his civil commitment at this point. They were definitely moving in that direction. If he was found guilty but mentally ill, once he was no longer a danger, he wouldn't have been released. He would have just been brought into the regular prison population for the duration of his sentence.